Hi, everyone. Thank you so much for joining us today for HAPS Estate Plan and Planning Education webinar series. My name is Annette Piniazic, and I am the Director of Grants and Major Gifts here at Houston Area Parkinson's Society. And we've launched this series in direct response to requests that we've had from our community members who had questions about estate planning. And our presenter for this series is Kathleen Wiesenthal. She's an attorney with Keever and Wiesenthal. And Kathleen's practice focuses on probate, real estate, and estate planning. And today she's going to be talking about estate planning for blended families. Um, Essentially, we will take questions after the webinar is finished, after Kathleen has had her presentation. We've reserved some time afterwards. So if you have any questions, please just use the Q&A tab at the bottom of your screen, and we will get to those at the end. And just a reminder that today's webinar is being recorded, and a link for it will be available on the HAPS.org website and also on the HAPS YouTube channel. It's not going to be available immediately, but it will be available within the next few weeks. And just a reminder, you can also go back and watch other webinars that Kathleen has presented for HAPS's community. So I'm going to log out, hand everything over to Kathleen. Thank you so much, and I'll see you guys after Kathleen's presentation.
Thank you so much, Annette. Thank you, Annette. I'm really looking forward to giving this presentation to all of you and to make sure that everybody understands what we are going to try to accomplish by educating everyone about what happens to your property when you have passed away, both with a will and without a will. At this point, let me see, I would like to share with you the beginning of the PowerPoint that I plan to share. Hold on. Can everyone see this? I hope. Annette, are you able to see that?
Yes, I am.
Good, good, good. Okay. So the reason I wanted to talk to everybody about blended families in that they are very unique when it comes to probate. If you have a will and you have stepchildren or you have children you've taken into your home or raised, it's always very lovely to include them in your will if you're going to. Having a will designating those persons who are not necessarily in your bloodline is a very important step in making sure that those people that you love and cherish are going to receive assets from your estate. Now, what happens if you don't have a will and you have a blended family, maybe a second or third marriage? I know that's stretching it, but there are some people that have had that circumstance. And if you do not do a will or you have an incomplete will, I wanted to go over with you the fact that the state of Texas does have a statute, and it's under Texas Estates Code, and it's hold on, I'll give you the exact numbers. Section 201.101, if anybody wants to Google that. And the idea is that it's giving you the parameters of what happens in the state of Texas if you don't have a will or an incomplete will. Who will be the recipients of your property according to the law? Now, if you had intended for someone else to get your property, then do a will. That's my advice right there. Real simple, do a will. But if you don't have a will or you have an incomplete will, this is what's going to happen to your estate. And this is what I'm going to go over with you. I had another PowerPoint that included the actual chart, that the Texas Descent and Distribution chart that is used all throughout the state of Texas. but it isn't quite working with the PowerPoint. I'm sorry. So what I'm going to do is very simply walk you through what the circumstances are for each individual circumstance. So for instance, let's start off with married persons with children. If you have children and not all of them are of the marriage that you are in currently, your separate personal property, and what that means by the word separate means anything you might have inherited or brought to the marriage before you were married, or that you inherited or was a gift from someone. Those things are considered your separate personal property. Some people, it would also include things like a checking account that you may have that was included money from an inheritance or from a piece of property that you had that you inherited, but your spouse is not on that account. So that's separate personal property. When you don't have a will or you have an incomplete will go 2/3 to your children, all of your children from all marriages, and 1/3 to the surviving spouse. That is what's going to happen unless you have designated someone else to receive this, but your spouse does not automatically get that property. The next situation is if you have separate real estate. And if you have real estate, maybe you inherited part of a family farm, you have an interest, maybe a 100th interest or something from your great grandparents' family farm. That separate real property, your spouse gets none of it. And again, this is when you don't have a will, you've not made any arrangements for your property. If you have a will, you can leave your property to whomever you wish. But when you don't, this is what's going to happen to it. So with separate real estate, all of your children, no matter what marriage they're from, or if they're, and it doesn't include stepchildren unless you've designated them to be treated as your children for whatever reason that you've done that, either adoption or whether you've made legal declarations that they're your children. All the children will take that property, your share in it, equally. The spouse gets what's called a 1/3 life estate. Now, I know it doesn't make much sense, but a 1/3 life estate means that, in simple terms, that the spouse will be able to, if they wish, declare that property as their homestead or declare a 1/3 life estate in that property. And as long as they are alive, they will be able to live in that property or use that property. And no one, even the kids who have all taken the fee simple interest in the property, cannot remove that person from the property. Now, obviously, there's going to be, if somebody has 2 or 3 pieces of property, for instance, the spouse can take life estates in all of that property if they wish. It's not the same as having a homestead. A homestead is where you live and where you're domiciled and where you pay taxes. The life estate would be where you are going to occupy the property, and you may occupy the property in many different ways. If it's a farm, you may decide to start proceeding to finish agricultural work on that property, or doing hay or putting cattle on there. And the children themselves who underlying have the interest in that property when the spouse dies, they cannot remove that person from that property. Obviously, there are a lot of other legal ramifications of a spouse claiming life estate. but you are going to have the opportunity to litigate that, and there's lots of negotiations that can go with that. A life estate for a spouse also has a value. So let's say the only thing you own is your residence. You bought it before you were married, and it stayed in your name for the duration of your marriage. And this, when you pass away, your surviving spouse gets a 1/3 life estate in that homestead, in that residence. The surviving spouse, if they choose to live there, if they don't abandon the property, because there is such a thing as abandoning it, and then the heirs can go in and take the property as they wish. Again, you may have to litigate. But the surviving spouse, that life estate that they have has a value. There's an IRS case, I'm sorry, an IRS statute that says that the surviving spouse 1/3 life estate means that you take the value of the property at the time of your death, you multiply that times 1/3, and then times a decimal number that corresponds with that surviving spouse's age. And this is all promulgated and disseminated by the IRS. The Internal Revenue Service does all of this. And then you multiply times that decimal, and that will give you what the value of the property is to the surviving spouse. So if, let's say all the kids say, we don't, do you want to move out, your stepdad or dad? And do you want to sell your share of the life estate with us? And we'll sell, excuse me, I'm sorry. We'll buy the life estate from you, and then we can do what we want with the property. And so that does have a value. You can't just say, okay, can you move out? And then we'll take the property. That's only if they abandon the property can an heir do that. And even then, they might still have to pay the surviving spouse the equivalent of that 1/3 life estate. Now, let's say that the children don't really want the house, and the surviving spouse has the 1/3 life estate. What if they want to buy the share of the children's share of their interest in the property? So if you have a piece of real estate and there's 5 kids and they've divided it 5 ways, the surviving spouse also could negotiate with the children to buy their shares. Obviously, if the surviving spouse wanted to sell the property, they wouldn't be able to do it without the children. The children and the surviving spouse have equal rights to the property, but the person with a life estate gets to live there. A person with a life estate has to pay the taxes and pay the maintenance and keep the property in repair and not let the property go to waste. Again, those are litigation issues, and let's hope none of you ever have to go there. But the majority of people find a way to make it comfortable between them and their kids or stepchildren, okay? Now let's talk about community property. If you're not familiar with what that means, everybody thinks they know what it means, but community property, according to the Texas Estates Code and the Constitution, is property that you buy, purchase, or acquire in some fashion, not a gift, not an inheritance, that during the marriage, from the moment you get married to the moment the first person passes, or until you get divorced. Those are all community property. Now, there's differences of opinion about this if you're talking about family law. We're not going to go into that. What we're talking about here is the probate version of community property. So anything, if you buy a house together with your spouse and it was community property, and you had children but didn't do a will, still your share of the community property is going to go to the spouse. Okay. Not separate property. This is different from any separate inherited or gifted property. That stays with the individual it was gifted to if they have not commingled it with the community property estate. So if your wife passes away and her half of the property would go to you, and then any share of community property when now that's when, excuse me, let me back up. When all the children are the children of the couple that are there now. So for instance, my husband and I have one daughter. When we pass away or one of us passes away, because our one daughter is a child of both of us, then either one of us is going to receive the other person's 1/2 interest in that real property. In Texas, as you probably know, we have a community property state, which means that when you buy a piece of property with your spouse, you own that property 50-50 with your spouse, unless you designate in the deed when you buy the property that there's a different kind of an ownership. Or you can even say that you guys are joint tenants with rights of survivorship. That's just something you might want to write down. We can always talk about it later. That's a pretty heavy designation, but it also makes for much easier probate planning if you need to. And again, it was called joint tenants with rights of survivorship. If you have children that are not your children together, so if one spouse brings children from another relationship and the other spouse brings children from the other relationship, the children of that person who passed away will, if you have a house, if my husband and I were married before and we both had 2 kids from each marriage, when I die, my half of the property, if I don't have a will go to my children, not to my spouse. My half of the community property, okay? If let's say there's some children that are not living with us even, and they're adults and they've moved away, but they are my children from a prior relationship, they get my half of the house, not the spouse. That's a pretty important point when a lot of people assume that if they have blended families, they have children from one relationship or another relationship, or their wife came to the marriage with different relationship. When your spouse dies, their half won't necessarily go to you, depending on this kind of statute. It is a little bit to get your mind around, but don't assume that the house that you bought 45 years ago with your spouse goes to your spouse, regardless of whether they have paid taxes all these years and they've contributed to the upkeep of the property. If you don't have a will, it's going to the kids, to the 1/2. So you would end up owning your half of the property with your spouse's children, whether you speak to them or not. And that's something that I want to really caution people about. If you don't speak to the stepkids or to the children by another marriage that are adults, and you don't have a will, you're going to have to get really cozy with those kids, because you're going to end up legally owning property with them. So that's the married person with children. Okay. Now, if you're married and have no children, If you have separate personal property, such as checking accounts, maybe an inheritance account, maybe some other accounts that don't have beneficiaries listed on them, that will all go to your surviving spouse. Anything that was yours, your personal property, your jewelry, your clothing, your furniture, all of that will go to your spouse if you have no children at all, either of you. If the decedent is survived by a mother and a father on separate real property, again, I've inherited property and I pass away without a will, my property would go legally, according to the statute, a quarter to my father, a quarter to my mother, and one half to my surviving spouse. Let's say my mother and father are not alive any longer. Then it's going to go to my siblings. My parents' share of the property is going to go to siblings, and the one half still to the surviving spouse. So if your parents aren't alive, you start at the top of the airship chart and you go to siblings and branch out. The siblings will receive 1/4 or one half of your property, your real property, your real estate. If you only have one sibling, they get the other half of your property. If you have 4 siblings, the 4 siblings are going to share that one half of your property with your surviving spouse. Again, with no will and with gaps in your will or things like that. If you have no children and you are not survived by a mother or father, and you are not survived by any siblings or other descendants of your siblings, like nieces, nephews, then your real property, your real estate, will go all to the surviving spouse. That's very rare that we have somebody that passes away that doesn't have nieces and nephews and cousins or things like that. It depends on the situation with the family or how young the decedent was when they passed away. But if they didn't have a will, you're most likely going to be sharing your residence with any separate real property will be shared with mother, father, sister, brother, and their descendants. Okay. Now, and that's if you have a home that, let's say I bought it, again, we'll go to that scenario that I bought it before my marriage and it stayed my separate real property during my marriage. Then you're going to be looking to the parents, then the siblings, to disseminate that property at the time of someone's death. On community property, it's all going to the surviving spouse. If you have no children, or no descendants, like maybe you have no children, but you have some grandchildren, okay? That won't apply. Your grandchildren will get the part that your children would have gotten. That's complicated too. By the way, this chart I gave to Annette. Annette hopefully will be able to, at some point, it won't be today, find an opportunity to post this chart for you so that you have the ability to look at the different scenarios, because they are complicated and they do depend on your unique situation. But if you have community property and no children, your surviving spouse will receive all of your community property real estate, which is good news to the surviving spouse. What can be daunting is that if you've been married to somebody for 45 years and they owned that house with only their name on it beforehand and never put your name on that property, there's going to be some concern with the children of that decedent who are are wondering if they have access to the decedent's half of the property because it may not have ever been designated as community property. Again, these are legal issues and it depends on the circumstances, but I just don't chance it. Do a will so you don't have to worry about who's going to be getting your property. And if you're the spouse of someone who owns separate property that your name's on the, not on the deed, but you live there and it's been your home for 40 years and you've been paying taxes and paying for maintenance and HOA fees, you might want to make sure your spouse has a will that leaves that property where they want it to go. And if it's not going to you, you might want to know that. It's important to know that so that you're not blindsided by it when somebody passes away. It's an awful situation to find out that the house you're living in belongs to your husband or wife's children rather than you. You don't want that to happen to you. And again, you can consult an attorney to find out if your particular situation requires some extra thought or some looking at, and whether or not a will is going to be necessary to make sure that the property is disseminated accordingly. And some people, they never intend for their spouse not to get the property. They just assume, and therefore they don't do a will. And there you go. You've got a legal issue with all of your spouse's children, some of which you probably have never spoken to, some of which are living under a bridge. That sometimes happens. How do you find them? How do you give them notice? You can't sell the property unless they're part of the negotiations and part of the contract. It's a very, very sticky situation. There is no out of that. So that's why I'm cautioning you ahead of time to make sure that you've got a will prepared so that, or at least prepare your deeds or your paperwork. There's other things you can do too, which you can talk to your attorney about. Lots of other things that your spouse can do. If they're just, adverse to doing a will, you might talk to them about doing something called a transfer on death deed. That's another, I think I've covered that in some other webinars. And that you would want to consult an attorney about too, to see if that's something that will work for you. If you're unmarried with children, your children take all of your property. And that's pretty much very simple. If you're unmarried, anything you own, separate. If you have, most of your property is going to be separate if you're not married any longer, because if you're divorced or widowed, then you've already established that most of the property is yours. But let's say that you're unmarried because you're widowed and you haven't resolved the issue of your homestead yet. That's going to be a problem about your kids taking title to your homestead. That's a pretty important thing to stick your kids with when you're gone and they're grieving and they're trying to pay taxes and they're trying to pay for maintenance or trying to sell the property because they can't afford to pay the taxes. These kinds of issues are definitely something you want to sit down with an attorney for. Don't let this go because it will be a headache. And I'm assuming every one of you loves your children and doesn't want to do that to them. So here's my caution, get some help. If you're unmarried and have no children, then we look again. That's the scenario where we go back again and look at mother and father. If your mother and father are alive, they will split your property. Even if they're not together anymore, they each get one half. If they are together, they each get one half. So, and that's an inheritance. So your property becomes their separate property. So mom might own half of it as her separate property, and dad owns half as his separate property. Even if they're not together, doesn't matter. If you don't know where the mother or father is, then do a will. I mean, don't let that slide, because we have to go, we as attorneys, we're gonna have to go look for mother or father. I'm going through a case like that right now, where we have been searching and searching and searching for the father. We finally found him, and he's deceased. He just died like 4 months ago. And so now we have to deal with the father's new family and etc. As you can imagine, it stretches your mind just talking about it. It can be rectified, but it's really involved, and it's not cheap. If you are survived by a mother and a father and siblings, then one half of your property, any personal property, any real property, goes to your parents or surviving parent, and one half to your siblings or descendants of that parent. So if you are single, you don't have any children. Let's say I was single and I have a house and I have no children, and I pass away without a will or without any kind of designation of where my property should be going, such as a transfer on death deed. Half of my property is going to go to my surviving parent. If I have a parent who is deceased, then their children, whether or not they're my siblings, are going to be the recipients of the other half of the property. So if my dad and mom were divorced, my dad got remarried, had 4 more kids, I pass away with no will, my mom would get half of it, my dad's children will get the other half. Now that's a mess trying to put that together. Let's not do that. I don't think any of you would wish for that to happen. If you're, let me see here, if you're not survived by either of your parents, your siblings or their descendants receive your property. So if my brother and sister were both alive, they would each get one half of my property. If my brother was deceased, all of his children would get my half of the property. And I mean, one half of the property, my sister would get the other half, and then she would have to share the property with the nieces and nephews or their children, the great nieces and nephews. These are all categories of dissemination that are very complicated. It requires gathering everybody up, giving them notice. You can't sell or move a piece of property without contacting them and having them be served, so that they know that they are in possession of a piece of property or an interest in a piece of property. And that includes things like the cash. If I have cash accounts that have no beneficiaries, that will also be divided the same way. It goes for real estate, and it goes for any other assets that I might have that don't have beneficiaries. So if I have, let's say, a savings account with $100,000 in it, and my sister survives, but my brother does not, and his children survive, my sister's going to be splitting that money. She gets 50%, and my brother's children or grandchildren will be receiving 50%, but then divided amongst their particular interests, which gets even more complicated as you go. For those of you who don't like fractions, doing airships for someone without a will is extremely painful. And if you're not into fractions, that's where I think you could benefit from legal advice and maybe even having some visuals, like the ones that I have here, that will help you kind of grasp the idea that pertains to your particular situation. Okay, let's move on a little bit here. Don't rely on your own law degree from the internet to prepare a simple will. Everybody says, I don't have anything and it should be just simple. Well, please analyze your familial situation. Look back at how many children you may have. If you have children that are minors, that's going to be an issue. We definitely have to prepare wills for them, or otherwise those children aren't going to get that money without going through hell and high water. Please try to get professional help, or at least a counselor at law or an attorney to, even if you don't want to do the estate plan and do a will, get counseling. Get a counseling on your particular situation. As you can tell from all of the scenarios that I've gone over with you, it's very complicated. It's very unique to your particular situation. And so you don't want to get there isn't a general idea of what can happen to your property if you haven't addressed the individual issues within your family. There's lots of ways to deliver your assets. We talked about the will, of course, transfer on death deeds. You can give some of your property away before your death if you wish. And that's again something you can talk about with a counselor, just with an attorney. And you just have a way of notifying people legally and effectually, enforceably, because you want to have a document that's enforceable, to give your property to people that you care about before your death. You don't have to wait till you're gone. So that there's an option there for people. You can have a memorandum attached to a will to instruct your executor on distribution of certain things. That again is something that we would have to talk about, or your attorney and you would have to talk about. There's something called ladybird deeds, that those are different than the transfer on death deeds. And I've gone over this in another webinar, but ladybird deeds are a way for you to still keep your life estate in your property, but you deed it out the fee simple interest to, let's say, your children. So if you feel like you're getting towards the end of your life, or you're just tired of dealing with the house, and you want to give it to your children now, but continue to have the life estate to live in that property, you can do something like a ladybird deed. A transfer on death deed, a ladybird deed takes effect the moment that you file that deed with the real property records of the county that the property is in. A transfer on death deed does not take effect until you have passed. When you are dead, then the deed itself becomes the transfer document conveying that property to the people that you love. Please make sure, along with wills and transfer on death deeds and everything else you're going to want to do, prepare powers of attorney, because what if you become incapacitated and you don't die for 10 more years? Who's going to take care of your assets during the time period that you are alive, but effectively unable to take care of your own assets? Powers of attorney are extremely important to do that. And that plays right into the discussion that we're having, so that you don't have miscommunications, you don't have people squatting in your house, that you don't have taxes going unpaid because nobody's able to do that for you. And you lose the property. It's one of the biggest assets you have, and it's very important that you keep that asset, maybe to also pay for your care. It might just be kind of a savings account, keeping a house that you could sell and use to pay for your care. These are all things you need to think about, and or get an attorney to sit down with you and talk and ask these questions. See if you already have something prepared. Conclusion is, take care to put your wishes into writing with legal counsel. You may have heard, and it is true, that if you write down a will on a napkin, that can be considered a valid will. But there's a lot of things that could screw that up. So I even have talked to people who just want to write their own will. So I will counsel them on what to put in their own handwriting in a will so that it is enforceable and that it can't be contested. That's the biggest issue, is being contested. And also making sure that somebody understands that you had competency. Contesting a will is usually the first thing out of the gate that somebody's going to say is not appropriate, is that they didn't have capacity when they prepared that will. Um, if you handwrote the will, it's going to be very hard unless there were witnesses watching you prepare that handwritten will that are able to testify that you in fact did know what you were doing and that you had full competency to be able to put put all of your wishes on paper. If you do not feel like you're confident in doing that, go see an attorney about a will and let them put your wishes into writing so that it's not ever going to be contested, because a will is notarized and witnessed. And then usually when you probate it, you're 99% of the time, you're going to have an attorney advocating for that will at the hearing, which will make that will a legal document once it's been probated. So all of your assets, and the executor has the power and authority to go forward and disseminate your property. If you have a blended family and you want your property to be split up between children, stepchildren, or just friends, even charities, things like that, you have got to put that very succinctly in writing so nobody is confused about what it is you wanted to do. Be honest with your attorney about your bloodline. I have had so many people come into my office and sit there and tell me, I'm the only child of my father. Well, it only takes me a little bit of background work to find out that's not true. And if I find out there's another family member, that means your whole estate requirements and the probate requirements are going to change, and so are the documents, and so is your hearing itself. The documents we have to file in order to move forward with a probate of someone who doesn't have a will. So always be honest with your attorney. I have also had people who didn't tell me that they had another child out of wedlock. That can be a huge mess if you don't tell your attorney that. Your will is private. Your will doesn't have to be shared with anybody but your executor. Okay. So if you have children outside your marriage, for instance, please tell your attorney that so that they can address that issue. If you, for instance, in the next sentence, you'll see, if you don't want to include that child in your estate plan, you have that right. And so we may want to insert language like, I give my love and affection to my son, John Doe. And if that son is not of your marriage, you're making it clear. You're declaring him and saying, I am not giving anything in my estate. Well, you're not saying that. You actually have to say that. I make no provisions for John in this will, that kind of a thing. There are ways to do that without it being divulged to your family that you have children outside the marriage. But it's extremely important, because if that child outside the marriage comes and contests this will, your family is going to end up paying all sorts of legal fees to try to contest this. And that's extremely expensive. That is not a cheap endeavor. You can leave your property to non-family members if you wish to, but you must name them very clearly, either a person or an entity. If you want to leave, 10% of your income to your church, you are absolutely allowed to do that. You do not have to leave your estate to your family members if you don't wish to. However, most people do, because they're as the legal words are, they are the natural objects of your bounty. So most of the time people are leaving it to their children or spouses. Another thing is, you don't have to leave your, if you don't want your spouse to have a half of your house and you want your children to have a half of the house, then say that. because you don't need to have the drama that goes with everybody fighting about that half of the house because it wasn't clear in the will. If it's clear in the will, it's clear to the court. All right. All right. I think I am done giving you the overall view of what to do if you are in a blended family scenario. So if you have questions about your unique situation, I think that Annette would probably be willing to read those out to me and I can answer some of your questions.
Hi, thank you. Okay, I am back on. Sorry, everyone. It's the perils of using a borrowed computer. We do have some questions, but before we get to them, Kathleen, I just wanted to remind people that the Texas descent and distribution chart that you mentioned, I am happy to send anyone who would like a copy of it. Just go ahead and email me at annette@haps.org. That's ANNETTE at haps.org. You can also feel free to call me, but it's probably better if you email me. But my phone number is 713-313-1669. And just let me know that you want the Texas descent and distribution chart, or you could just say Kathleen's chart and I'll know exactly what you mean. We do have quite a few questions. The first one up, are common law marriages still a thing? How do they relate to estate planning?
Common law marriages are they're not a thing anymore. They can be. What is happening is there's a sea change of the law and the judges who are recognizing common law marriage. There's circumstances where common law marriage will be recognized, but when it comes to things like giving half a house to somebody because they say they're the wife, that has to be proven by paperwork or legal documents. So if you are in a common law marriage and you don't want to get married by legally get married, make your way down to the courthouse and register your common law marriage as soon as possible, because that's the only way now to prove that you've been in a common law marriage, unless you have umpteen witnesses and paperwork and filing taxes together and things like that that will prove that you've been in a common law marriage. Again, some of what I'm saying is accurate in one court and maybe not so accurate in another court, okay? But for probate, they want to see paperwork that says that you were a common law spouse, a legal paperwork. And again, if you don't want to get married, at least go to the courthouse and register your common law marriage.
Okay, I didn't even realize that was something that one does. Uh,
Yeah. Did
Interesting.
I answer the other half of that question?
Well, how does it relate to estate planning? So does it make a difference? I mean, as
A
far as,
huge difference.
okay.
A huge difference, because if you're trying to hold yourself out as the spouse and the other person has children that are not your children, you may have no standing at all for the house you've been living in. And that's going to be a problem. That's going to be a shock. Or you may have no rights to the checking account if your name's not on that checking account. Things like that. Filing for probate will be an issue. So yeah, definitely do something to make it legalish. Uh,
Okay, next question is, if you're a young person with Parkinson's, how do you handle estate planning with minor children?
you would handle that by, um, you would want to make sure that you've designated guardians in your will for your children, that you've made arrangements for your children in some way. If you require powers of attorney, for instance, if you have intermittent incapacities, It may not be a long-term incapacity, but if you have intermittent periods where you're unable to care for your children legally or personally, you may want, there's lots of documents that you can do that can designate someone else to be your agent or to help you out in a situation like that. There are ways you can do that that streamline things. So for schools, there's documents you can file with the school to tell them that this person is my agent when I'm incapacitated. That you might have, if these are little children, you definitely have to have, I would say, powers of attorney. So somebody can walk into a bank or walk into the school, or HIPAA releases. You might even want to do a HIPAA release that says that this person is allowed to get my children's information when I am unable to do so, or I'm unable to be there in person or things like that. So there's lots of ways to deal with that. Yes.
Okay. You mentioned during your presentation that if you want to not leave something to a family member, that you
Mhm.
need to specifically state that. If you have children who are involved and you want to leave part of your estate to some of those children and not the others, would it suffice
Mm.
if you simply stated the names of the individuals that you want to leave part of your property to?
No,
Oh,
because what will happen is, let's say I have four children and one of them is a problem. Or let's say not even a problem. Maybe one of them I've been supporting their whole lives. And so when I die, I want my other three children to have the benefit of my estate because the fourth one has already been receiving my estate all along. Those kind of circumstances, or if you want to cut somebody out in general, which does happen in families sometimes. Um, and what you need to do in order so that it's very clear and it cannot be contested, well, okay, let me make this caveat. Anybody can contest your will for any reason. Whether they're successful or not is another matter. But I can contest a stranger's will if I want to, if I feel like I have standing to do that. But let's go back to the child who's been disinherited. If you just leave them out and only name them, that's going to be an issue because they'll say, hey, they forgot to put me in the will. I'm entitled to my 1/4. And they were probably incompetent and couldn't remember me or something like that because we haven't spoken for years, or I moved to California, that kind of a thing. You don't want those kind of contests to come up because they're very, very expensive for the family. What you would want to say is, and here's some of the language I've used in the past, and I gave one of them in this presentation. I give my love and affection to my son, John Doe. And but I'm not leaving him making any provisions for him in my will. Okay. But you can say, I love you, but you're not getting any of my estate. Basically, that's what that's saying. You can also say, I'm giving everything in my estate to my three children, my fourth child. I have been giving them resources throughout my lifetime. And so I'm sharing the rest of it with the other three, that kind of thing. There's different ways you can put that. Some people even say, I am leaving out John Doe because he's familiar with the reasons. You can actually say that. And then if they say, well, I don't know what he's talking about, you usually have witnesses that can explain what those reasons might be. Um, so there's lots of different ways to deal with it. It depends on the situation. There are very tasteful ways to do it, and you can be as blunt as you want. It's your will.
true. Can you state in a will an even split percentage split between children and stepchildren, or do you need to specifically name the people that you're leaving something to
Always,
someday?
always name them, always. And even if they're just a friend of the family that you took in and you're taking care of and you love them and you want to give them some of your estate, put their name in there and what the relationship is to you and that you're specifically leaving them something. If you just say to my children, how are we going to determine, how's the court going to determine who your children are, or how sometimes your executor is not a family member. If it's your best friend down the street, how are they going to identify who your children are? It's so much easier when you identify those people in a will rather than not, because you don't want that to be misconstrued. Now, if you have like I just recently did a will that said to any grandchildren or descendants of my children. Okay, now that can be proven. You can get birth certificates to prove that these 4 kids are the descendants of your daughter, you know? And so if you wish to leave money to any descendants who aren't even born yet, you can do that.
Okay, what happens if you find an extra sibling through one of these genetic testing companies, but you're not sure that your parent has any knowledge of this person? The parent was never part of this person's life, and you didn't tell your parent about this finding. If you bring this bonus sibling to meet the parent before the parent dies, can the bonus sibling claim a part of the estate?
The bonus sibling can claim a part of the estate no matter what. Okay. I actually had that happen in my own family. My grandfather was very friendly and he had a few women who had children by him that we found out many years after he passed. So there was no inheritance to get, everything was already done. But if those people had come out when my grandfather died, they would have had every right because they're in his bloodline to be considered children of his. And so now we just make them part of our family as cousins. So,
Okay, and we're almost out of time, so I'm just going to do this one last question. I wanted to make HAPS a beneficiary on an insurance policy. They said I should just put a line in my will instead. Is that sufficient?
well, it depends. If your insurance policy is paid out to your spouse, that money goes specifically to your spouse. Now, if you state in your will that I would like to leave 10% of my insurance policy funds to HAPS, that will probably still be enforceable, but you're relying then on the executor to do it properly. So you have a choice of either letting the insurance company put HAPS as a 10% or 20% beneficiary, or putting it in the will that the proceeds of my insurance policy, which are going to my spouse, or something to that effect, 10% of it should go to HAPS. That's a complicated issue because it depends. If your spouse doesn't survive you, where's your insurance money going? And if it's going into your estate, your executor can handle that. They can take care of that. But if it's not going into your estate and then it's going to your kids already are the legal owners of those funds. Not, and you would have to clearly state that there are funds that are going, from the insurance company. So 2 HAPs.
Okay, we do have one more question. I'm going to pop it in because we still are going to be under our allotted time.
Okay.
What's the look back period after an estate is settled? Like if the estate is settled and someone comes along to contest it, like an unknown child, can the estate be reopened?
It can. There are some very complicated civil procedures that go along with that. But let's say if an estate has already been opened and closed, and then there's an unknown heir that came up that wasn't mentioned in the will, once they have notice that their natural parent had passed, they only have a certain amount of time. And I'm not going to quote that to you because I have no idea. I think it's 2 years, but I'm not sure. Maybe longer than that. But you can't just bring a suit 50 years from now. You have to have some kind of civil procedure that governs that and how long they have to check in. But if they have noticed 10 years down the road and they just found out this person was their parent and they've passed, they can make a plea to the court for something. But again, how are you going to guarantee anybody has any money left to give you? So,
Do any of those things change on a state by state basis or
oh, sure, sure.
okay.
Every state's different in how they deal with that. Um, but it would have to be dealt with on an individual basis. Once again, these circumstances, the fact pattern, as we call it in law school, the fact pattern, when that changes a little bit, the outcome changes. So you have to make sure you've gone to see a legal counselor and asked all the pertinent questions to see if you've got standing. Standing means the right to go in and enter into that probate and try to make a plea. So
Okay. Well, our time is up. Thank you so much, Kathleen Wiesenthal with Keever and Wiesenthal. Just a reminder that this has been recorded, and within a few weeks, we should have this up on our haps.org website and also our YouTube channel. And also, if you would like a copy of the Texas Descent and Distribution chart that Kathleen has referenced in her presentation, please just contact me, shoot me an email at annette@haps.org, and I'll be happy to send a copy to you. Thank you so much, everyone, for joining, and we look forward to seeing you at the next presentation, which we don't have a date set yet. It should be sometime this fall, and you can always feel free to look back at any of Kathleen's past estate planning webinars done on behalf of HAPS. They're on the haps.org website. There should be a link, and also our YouTube channel. Thank you so much, Kathleen. Thank you so much, everyone, for attending.
thank you.